Good morning, everyone. I'm Barbara Vanich, Acting Chief Auditor and Director of Professional Standards at the PCAOB, and it's my pleasure to get to be with you today. Firsts are always exciting, and I would like to welcome all of you to this first meeting of the Standards and Emerging Issues Advisory Group of the Public Company Accounting Oversight Board. I want to extend a welcome to our members, observers, board members, and of course, the public watching this meeting. We have a full agenda. In our first hour, we'll spend some time hearing from our board and getting to know each other. Then we'll have a brief administrative overview, followed by an overview of the PCAOB, where I will be joined by my colleagues George Bodick and Patrick Bryan. George is our director of the Division of Registration and Inspections, and Patrick is the director of our Division of Enforcement and Investigations. Members will have an ethics overview during lunch, and after lunch, we'll resume our public meeting. In the afternoon, we'll have a session on the PCAOB strategic plan, followed by a session on our standard setting agenda. We strongly encourage members' questions and comments throughout the meeting. As a reminder, if you would like to say something, please use the raise your hand function. If that's not working, just type something into the chat function. No need to write your question, just a call on me. A few characters will work, and we'll make sure to get to you. During the day, we will try to respond to comments in the order that you raised your hands. Thank you in advance for your patience. We all hope that technology is on our side today. If you have any technical difficulties during the meeting, please email Kent Bonham. My final responsibility here before we kick things off, although some may repeat it, is to state that for all representatives of the PCAOB speaking this morning, our views are expressed today are our own and do not necessarily reflect the views of the board, its members, or other staff. And with that, it's my pleasure to start the first session. Again, I'm Barbara Vanich. I've been with the PCAOB for over 13 years, and it's been my pleasure to serve as acting chief auditor for the last 18 months. In my time at the PCAOB, I've been part of a number of standard setting project teams, including our projects on estimates and specialists, and before that, the attestation standards relevant to broker-dealer attest reports. In my current role, I get to work actively with many talented teams working on the various agenda projects. I'll now turn to our new chair and then to board members to introduce themselves and make brief statements, and then we'll call on members in alphabetical order to briefly introduce themselves. Chair Williams.
Thank you, Barb, for that introduction and for all the work that you and your staff have done in preparation for this meeting today. I'm really excited to be here with all of you as we kick off the first meeting of our newly formed Standards and Emerging Issues Advisory Group. We really recognize the importance of the advisory groups here at the PCAOB, and I and my fellow board members made it a top priority to initiate the process of reconstituting these valuable resources in less than a month after my arrival. And we sought comment on the potential structure for the advisory groups and initiated a nomination process. And that's what ultimately led us to this meeting here today. I can't emphasize enough how important it is for the board to hear your perspectives. This advisory group represents a key avenue for us to hear the views of investors, investor advocates, financial statement preparers, audit committee members, academics, and representatives of accounting firms, all in the same forum. And we're really interested to hear your thoughts and ideas on our standard setting activities and other matters such as emerging issues that are related to the PCAOB's oversight activities. I look forward to working collaboratively with you in advancing the PCAOB's mission. You're really an invaluable resource for us, and I thank you for volunteering to be part of this important group. Last week, we had an initial meeting of the newly formed Investor Advisory Group. If you were able to watch it or participate, in the case of Jennifer, Sandy, Lynn, and Jeff, we received great input from the members, and I'm confident that our discussion today will be just as beneficial. In addition to Barb and her staff, I want to thank the other talented staff members of the PCAOB who assisted in preparing for today's meeting, including Kent Bonham and the other staff in the Office of External Affairs. Thanks, Barb.
Board Member Disparte.
Thank you, Barb, and good morning, everyone, and thank you for being here. I, too, am, it's a pleasure to be here, and I know many of you, but for those of you I don't know, I'm looking forward to getting to know you and, in the months and years to come. I joined the board in 2018 after a long career in where I dedicated myself to high quality financial reporting, both as a corporate chief accounting officer and as an auditor, and now as a regulator. And I know that we will be better at what we do in terms of our regulation, our standard setting, our policies and programs with getting input from all of you. We have, you represent a really diverse array of experience and expertise that is going to be invaluable to us in terms of getting your perspectives, your advice as we move forward. There are many environmental factors impacting the profession, as always, but some big ones: technology, emerging expectations of new assurance products, and many others that I think your input will help us in achieving our very ambitious standard-setting agenda that you've probably seen. So, thank you for being here. Look forward to partnering with all of you, and look forward to a great day today. And I will echo Erica's thanks for the staff, Barb, Kent, many other folks on of our talented team that have helped put today together. So thank you for that.
Thank you, Dwayne. Board Member Ho.
Issues Advisory Group of the PCAOB. As Chair Williams and Board Member Disparte already mentioned, the SEAG is one of the most important means by which the board will gain input and insights on how the PCAOB should be devoting its time in setting public company auditing standards and thinking about and addressing emerging issues that, among other things, affect audit quality. I expect to learn much at these meetings, and I want to express my thanks for your willingness to serve on the SEAG and being here today. Hopefully, we will soon meet in person. One thing that I'm sure you already know is that the PCAOB is embarking on a new and ambitious phase in standard setting. Thanks to the leadership of Chair Williams and Acting Chief Auditor Barb Banich and her team, the PCAOB recently published a standard setting agenda not only for the next 12 months, but also for the years ahead. This standard setting agenda is dynamic. That means the PCAOB intends to review periodically the standard setting agenda, and with your input, it could change depending on, for example, emerging issues affecting audit quality. This means that the currently identified standards could move down the timeline or even be replaced by a different set of standards. I know that my fellow board members believe in this dynamic and nimble approach, and we will keep our ears to the ground for emerging issues on the horizon. I ask that this be an area of focus for the SEAG. Now, I'm sure you can sense how delighted I am that emerging issues are an integral part of the SEAG charter. As a regulator, the PCAOB has a duty to be forward-thinking when evaluating the impact of technology and data on the future of auditing, and proactively address them in our standard-setting agenda. I look forward to working with you in the months and years ahead. Thank you.
Thank you, Board Member Ho. Board Member Stein.
Good morning, everyone. I'm pleased to join my colleagues in welcoming you to the first meeting of the Standards and Emerging Issues Advisory Group, which we've been fondly calling SEAG because it's easier to say. All of you are highly credentialed and you're experts in your fields. Some of you are auditors. Many of you are adept at putting together a full set of financial statements, and all of you care deeply about the strength of the American capital markets. You're here to provide us with your best thoughts on maintaining and building trust in the financial statements of American public companies. So needless to say, your job is important. You will be advising us not only on potential changes in the standards for audits of United States public companies, but as Christina was just saying, on emerging issues that will affect what auditors should do and how they should do it. We're very pleased that the members of the SEAG represent diverse perspectives and viewpoints. However, you are united in a common purpose, the fact that a superficial audit serves neither investors nor the public interest. A superficial or perfunctory audit is a wasted expense for a public company and a wasted effort for all involved. Moreover, it conveys a false sense of security to the capital marketplace. On the converse, a rigorous audit can help the company's management identify risk before they become problems, zero in on internal control problems, and evaluate and improve corporate policies and procedures. Most important, a rigorous audit contributes to investor confidence in our capital markets, the engine of our economy. It's fitting that you begin your work today. 20 years ago this week, the bill that became the Sarbanes-Oxley Act passed out of the United States Senate Banking Committee with the unexpected support of 17 of the 21 committee members. The bill was meant to, quote, address the systemic and structural weaknesses affecting our capital markets, which were revealed by repeated failures of audit effectiveness and corporate financial responsibility in recent months and years, end of quote. 2 weeks after the bill came out of the Banking Committee, there was the collapse of WorldCom, which actually swept away opposition to the bill's passage. The juxtaposition of those two events reminds us that our work together is important and it goes beyond mere words on the page. It is about trust. Without trust, our capital markets grind to a halt. Ultimately, auditing is practical work in the preparation and dissemination of financial statements. It is foundational to the integrity of our capital markets. Further, I think the value of the audit must be commensurate with its cost. That is how I see our charge. Through a practical lens, we must aim to protect investors and further the public interest in the preparation of informative, accurate, and independent audit reports. So again, I want to thank all of you for agreeing to serve on this committee, and I look forward to working with you going forward. Thank you.
Thank you, Board Member Stein. Board Member Thompson?
Thank you, Barb. Good morning, everyone. Welcome to the first of our Standards and Emerging Issues Advisory Group. I'd like to join my fellow board members. This is an exciting day. We've been looking forward to it for a very long time. Last week, we convened the first meeting of our Investor Advisory Group, and today we take the next step in PCAOB's very deliberate efforts to ensure that we hear and consider the diverse perspectives of all of our stakeholders. The PCAOB's mandate is to protect investors. To successfully achieve this mandate, there are certain mission-critical elements that must be incorporated into our strategy, one of which is to have boots on the ground. You are our boots on the ground. The perspectives you share with us will inform our work as we consider existing standards, proposed standards, and potentially new standards. The SEAG will also look prospectively around the corner, so to speak, to identify and discuss emerging issues that could be important to investors in our capital markets. Please excuse my occasional use of military analogies, but one of the important perspectives that I bring to the PCAOB is that of having a 32-year career in the United States Air Force. I held a number of positions leading complex organizations in matters involving mission readiness, life, and safety, where communication and collaboration weren't just options, but essential for success. Following my transition from the Air Force, I became a federal government executive managing significant operations at the Department of Agriculture and the Commodities Futures Trading Commission. These experiences may seem very different on their face, but I will tell you there is at least one common thread, which is that my decision-making benefited immensely from the availability of many perspectives. There is little doubt that most decision-making is better when rigor and being inclusive undergird the process. The expertise that the SEAG brings to our process will be invaluable. I want to close by thanking the staff of our Office of Chief Auditor, Barb, you and your team, Office of General Counsel, and the Office of External Affairs, who have worked hard and cooperatively in planning today's event. And thank you.
Thank you, Board Member Thompson. I will now call on members in alphabetical order to introduce themselves. I'll note that Bob Hirth is unable to join us today and sent his regrets. I believe that all others are present. So with that, John Bendel.
Yep. Hey, Barb. Thanks. Good to see you today. Again, happy to be here, excited to be here. John Bendel. I am principal and the international CFO at the Vanguard Group, currently based in London. I've been with Vanguard for a little over 5 years, holding a number of different roles, including Chief Accounting Officer, Treasurer, and our Fund CFO. Prior to joining Vanguard, I spent over 20 years in the auditing profession as a partner at KPMG in the Big Four, working both internationally and in the US. I think a lot of the board members really captured it well, the passion to serve the capital markets, and I really look forward to working with the PCAOB board, the PCAOB staff, and my fellow SEAG, I got that right, Barb, members on the advisory group. So thank you, and look forward to engaging with everyone.
Thank you so much, John. Preeti?
Good morning, everyone. My name is Preeti Chowdhury. I'm an associate professor at the University of Arizona in Tucson, where it is hot, hot, hot these days. I guess my research has mostly been about using large amounts of data to draw conclusions about capital markets with an emphasis on regulatory interests. And a few years ago, I did a fellowship with the PCAOB where I got to access much of the proprietary data the PCAOB gathers through their inspection process. And I have a number of research projects and papers that use that data, which has given me kind of a deeper knowledge of the PCAOB. So I'm excited to share that insight with you and to learn from all of you and the benefit of furthering the mission. Thank you.
Welcome. We look forward to it. Brian Croto?
Hi, good morning, Barb, and good morning, everyone. Certainly, I look forward to interacting as well with the board staff and my fellow SEAG members. But I'm Brian Croto. I'm a partner in the National Quality Organization at PwC. I serve as our regulatory risk and quality control leader, and in that role, focus on all matters related to audit quality, working with our full team in the National Quality Organization. Certainly before that, I've been involved directly in the auditing of public and private companies. And over the last couple decades, I've spent a decade of my career at the SEC, where most recently from 2010 to 2016, I was the Deputy Chief Accountant in the Office of the Chief Accountant, working very closely with the PCAOB over those years. So again, I very much look forward to working with everyone, and I appreciate the opportunity to be here today.
Thank you, Brian. Christine Devine?
Good morning, everybody. I'm Christine Devine from Deloitte. I lead our national office for the audit and assurance function, which is our entire quality network. So our accounting and auditing consultation, our risk, our regulatory, and our monitoring function. I've been with Deloitte over 20 years now, and prior to that, I spent over 8 years at the SEC in the Division of Corporation Finance. It is a privilege and an honor to be on this committee to support the important role that the PCAOB plays in strengthening our capital markets and improving high quality audit. So thank you for having me.
Thank you. Susan DeRoss?
Good morning, everyone. Thank you, Barb and the board and everyone else serving on the board. I do look forward to participating in the SEAG and doing whatever we can to improve the quality of financial statements and protect investors. I am the executive director at Harvest Investments. I oversee all of our valuations. I'm very involved in financial instruments, reporting standards, and I serve on quite a few other committees that work with standards. I serve on the Standards Review Board for the IVSC, and I do chair the AICPA Financial Instruments Advisory Group. My background is in trading and structuring mortgage and asset-backed structured product type paper. So I bring a lot of varying experiences, and I look forward to working closely with all of you and getting a whole bunch done. Thank you so much.
Welcome. Thank you. Ron Edmonds.
Thank you, Barb. Good morning, everyone. I'm Ron Edmonds. I'm the Chief Accounting Officer at Dow. This is my 30th year with Dow. I was in public accounting for a few years prior to that, as well as a couple other companies. It's great to be here. I'm looking forward to working with everyone to enhance the mission of ensure it's fulfilled of the PCAOB. I'm on the Committee of Corporate Reporting with FEI, and in that role, I've been the liaison with the PCAOB for a number of years, and I always thoroughly enjoyed that interaction, and looking forward to our continued efforts here.
Thank you so much, Ron. David Fabricant.
Hey, Barbara, thank you. Hello, everyone. David Fabricant. I am the Deputy Controller for American Express. I've been with the company for about 12 years, but I do bring over just about 30 years of controllership experience preparing financial statements, working very closely with auditors. I'm really glad to be here, looking forward to helping the board as they evolve their standards and their mission of providing high-quality audits. And all of the opening comments from the board members really resonate with me. I'm certainly excited after hearing your perspectives on what you're looking for this group to do. Board Member Thompson, the boots on the ground references is what I hope to do from a preparer's lens and contribute to the extent that I can to this group to help the board in its mission. Very glad to be here. Thank you, Barbara.
Yeah, thank you so much. Margaret Ferran. I don't see Margaret. She may have had to drop. We'll come back to her if she rejoins. And Jim Hunt, you're up next.
Good morning, and thank you, Barbara, and thank you, members of the PCAOB board, for your warm welcome to all of us. I spend my time as a corporate director, been on and continue on a half a dozen corporate boards as chairman of the board and largely as chairman of the audit committees. I spent my executive life for the 20 years at Disney, and prior to that, I was a partner with Ernst & Young. So I've had the ability to work around and with auditors and controls and internal controls over financial reporting for a very long time. Have observed the workings of the PCAOB from its very creation and have a great interest in the mission of the PCAOB, because I've always been a great believer, as was said by board member Stein, that quality audits do matter to the formation of capital in the capital markets, and not only here in the United States, but globally. So I'm thrilled to be with you all, and I look forward to the work that we can do and the service that we can provide. Thank you.
Thank you so much. Jennifer Joe.
Good morning, everyone. My name is Jennifer Joe. I am the Whitney Family Professor of Accounting at the University of Delaware. I'm both honored and excited to be invited to serve here on the SEAG, as well as one of the 4 liaisons with the IAG. I'm an academic who applies all of my experience as a former auditor. I've been engaged with the PCAOB from its initial years when Gary Holstrom invited several of us academics to an annual conference to discuss critical issues with board members and staff. And I also served to bridge the gap between academics and auditors during my 2-year role as an academic fellow at one of the global accounting firms. And I currently serve as a committee member for the Audit Access Research Committee for the Center of Audit Quality. I think we have a lot of work and a lot of opportunity ahead of us, and I look forward to collaborating with my fellow members of this group. Thank you.
Thank you, Jennifer. Josh Jones.
Yeah, thanks, Barbara. Hello, everyone. I'm Josh Jones. I'm a partner at Ernst & Young in our professional practice group for the last 2 years. I've been our America's Director of Audit and Chief Auditor. Prior to serving in the professional practice group of Ernst & Young, I spent 3 years at the SEC in the Office of the Chief Accountant, where I had the opportunity to work with Brian and a number of folks here at the PCAOB on a number of issues, as well as spent a year at the Center for Audit Quality, leading up a number of their professional practice and research efforts. And very excited to be a part of the group, and looking forward to all of the interactions and activities we have on the agenda.
Thank you, Josh. Robert Neckel.
Hello, I'm Robert Neckel. I'm a longtime professor at the University of Florida. Technically, my title is Fisher Eminent Scholar in Accounting. I've been here over 40 years. I'm currently visiting the University of Auckland in New Zealand. So when I say good morning, I mean literally early morning. I have been previously on the Standing Advisory Group, so it was interesting to see how that worked, and I'll be very curious to see how this group works. I have done research in auditing issues for well over 40 years now, many field studies with major accounting firms, and I am excited and very interested in the continuation of evidence-based standard setting at the PCAOB, which is a strength that I think has been fairly unique over the 20 years that the PCAOB has existed. So thank you for letting me join you.
Yeah, thank you so much, and thank you. You probably win the award for how many time zones crossed to join us today. Sarah Lord.
Thank you, Barb. I'm Sarah Lord. I'm the Chief Auditor at RSM US and also a member of the Board of Directors. I'm also the Chair of the AACP's Auditing Standards Board. In my role at RSM for Chief Auditor, I oversee audit and accounting policy, audit innovation, technology, and quality management. So kind of like to say everything our auditors need to do their jobs. I've been at RSM for about 10 years. Prior to that, I was at a regional firm, Boulay, in a combination of client service, SEC serving roles, as well as consultation roles, and began the first decade of my career at Deloitte in, again, a combination of client service, national office, and global regulatory and public policy roles. And I would just like to, thank the board members for a really engaging welcome, and all of the staff for the work that you've done. We all know how hard it is to prepare for these meetings and make sure that virtually they're interactive, and it looks like a wonderful agenda. So as I think Dwayne had mentioned, it's fun to see some familiar faces and also new faces that look forward to really getting to know and help and appreciate being part of this board. Thank you.
Thank you, Sarah. Melanie Lubin.
Good morning. My name is Melanie Lubin. I am the Maryland Securities Commissioner in the Office of the Maryland Attorney General. I've held that position for 24 years. I also have the privilege this year of serving as president of the North American Securities Administrators Association. I've actually spent my entire career in the Maryland Attorney General's office in the Securities Division. I've headed the corporate finance unit in the past, as well as the investment advisor broker-dealer unit. I've really spent my entire career as the boots on the ground for investor protection, and that's a high priority, or my highest priority, and has kept me, very much engaged in this space for the past 36 years. I also have the privilege of serving on the Financial Stability Oversight Council as the state representative, and I've held that position for us since 2015, and I very much look forward to learning a lot from this group and appreciate the opportunity to serve on the group. So thank you very much.
Thank you, Melanie. John Lakomnik. I think you're on mute.
Hello, everyone. Thank you, Barb, and hello, everyone. I'm a longtime institutional investor. I want to thank Chair Williams and the board for reconstituting the advisory committees. Like Professor Neckel, I was a former member of the Standing Advisory Group, and I thought that it provided great situational awareness, as the board said, seeing around corners to the PCAOB. So I hope that will be a value for this too. I have had various institutional investing assignments in my career. I ran the New York City Pension Fund investment side. I've been a fiduciary or a trustee for about $100 billion. I currently serve on the board of the VEDEC Mutual Funds and chair that audit committee. Finally, I would also say, since Board Member Stein mentioned the history of the PCAOB, that the importance of solid auditing came to the fore when I was on the creditors committee for WorldCom and Adelphia, trying to put together both those accounting statements into something that resembled sense, and we couldn't do it. So I applaud both the PCAOB's mission and the fact that the current board members have very clearly stated the link and the purpose in terms of caring about our capital markets. So I look forward to being helpful to the board and the staff however I can.
Thank you so much, John. Jeff Mahoney.
Thanks, Barb. Good morning, everyone. I'm General Counsel to the Council of Institutional Investors. We represent public, corporate, and union employee benefit plans. Combined, our members have about 40 assets under management. Our focus is on corporate governance and shareholder rights, but we are longtime supporters of the PCAOB and its mission. So, all of you and to today's discussion. Thank you.
Thanks so much, Jeff. Steve Morrison.
Good morning, everyone. My name is Steve Morrison. I'm a partner at Cohn Resnick, where I also serve as the National Director of Audit. I'm primarily responsible for audit quality initiatives and focused on audit quality matters. Before that, I served my entire career at a large regional firm based in South Florida, where I was working on private and public company engagements from staff through partner level. And from 2015 to 2018, I served on the AICPA's Auditing Standards Board. And I'm very happy to be here and look forward to working with everyone.
Thank you so much, Steve. Dane Mott.
Good morning, everyone. My name is Dane Mott. I'm a global accounting analyst at Capital Group, a large investment firm focused on active management, fundamental research. Kind of see my role as kind of a translator between the accounting world and the investment world. A lot of just fundamental research, looking at the financial statements from an investor's perspective with an accounting background. Have about 20 years of experience, 7 with Capital, and prior to that, within equity research at firms like JP Morgan.
Thank you so much. Welcome. Sandy Peters.
Good morning, everyone. I'm Sandy Peters. I work for CFA Institute, where I look after our investor member interests as it relates to information for investment decision making in the realms of financial reporting and auditing and increasingly sustainability information. I feel like all I do these days is the SEC's climate proposal. Prior to coming to CFA Institute, I was corporate controller at MetLife, and prior to that, I was an audit partner at KPMG, where I specialized in financial services and specifically insurance. I was a previous member of the SAG, and I'm a member of the Investor Advisory Group, like several others who have introduced themselves. I want to thank the board and Chair Williams for their efforts in reconstituting these advisory groups. I think they play an important role in engagement and communication of the activities of the board. And so we appreciate their efforts in standing them up quickly and their intense interest in engaging investors in the process. I also think I wanted to just comment on Kara's reference to the 20 years since Sarbanes-Oxley. I think that having spent the better part of the last 2 years in the audit work that I've been doing, looking at UK audit reform and audit reform in Europe, I think that the Sarbanes-Oxley Act and the PCAOB's efforts are very important to investors and to the audit profession. And I just wanted to specifically point that out. I think the audit profession, having been an auditor, is particularly important to investors and has a lot to add to the value that investors get from financial statements and financial information. And I look forward to being a part of the group. Thank you.
Thank you, Sandy. Glad to have you. Diane Rubin.
Yes, thank you, Barbara, and thank you to the entire board for such a warm welcome. One of the benefits of having a name late in the alphabet here is that I can hear all of your backgrounds and comments. So I am indeed very excited and honored to be working with all of you. I think it's going to be a terrific group and a terrific experience, and hopefully very helpful to the board. I am currently an independent director and audit committee chair of a public company, First Foundation. I am also a retired audit partner and in charge of quality control for Novogradac and Company, headquartered in San Francisco. I spent a large part of my career focusing on consumer protection by serving 2 terms on the California Board of Accountancy, which licenses and disciplines all the licensees in California, and then served for 9 years on the board of NASBA, the National Association of State Boards of Accountancy. I was a member of the Auditing Standards Board, and most recently, I was a trustee with the Financial Accounting Foundation. And I look forward to working with all of you. Thank you.
Thank you, Diane. Keisha Smith.
Good morning. My name is Keisha Williams Smith. I'm an assistant professor and graduate program director and director of the Center for Accounting Diversity at North Carolina A&T State University. This is a full circle moment for me because before I entered into academia, I was actually a PCAOB inspector. So thank you to Chair Williams, the board members, and the staff for this opportunity to serve on the SEAG. And I am excited about this opportunity to have open and transparent and engaging discussion about audit quality and how that impacts our capital markets. Also in academia, my interests are in audit regulation, imagine that, and also auditor decision-making and accounting diversity. And I also serve on the AAA, which is the Accounting Academic Association Auditing Section Standards Committee, where we also look at emerging issues as well. So thank you so much for the opportunity, and I look forward to working with all of you.
Thank you, Keisha. Lynn Turner.
I am a former audit partner with one of the large international firms where I worked for 20 years before becoming CFO of an international semiconductor and storage systems manufacturer. From there, I became the SEC chief accountant. I'd previously done a professional accounting fellowship at the SEC. After stepping down from the SEC, I became one of the founders of Glass Lewis, the proxy firm. And most recently, I've been members of boards of public companies and institutional investors. Thank you.
Thank you, Lynn. John White.
Good morning, everyone. I'm John White. I am a governance and public company corporate lawyer at Cravath, Swaine & Moore in New York, where I've, I guess I'll say, spent almost my entire professional career. A while back, I spent 3 years in Washington as the director of the Division of Corporation Finance at the SEC, which interestingly was the period when the internal control standard, AS2, was recast as AS5. And so I've spent a lot of time at that stage with the PCAOB. I've also previously served on the Standing Advisory Group, also have served on the FASB Advisory Group. Although I'm a lawyer, I majored in accounting, and I've had a lifelong interest in accounting and auditing, and feel very close to all of you in the profession. And I am very excited to be serving on the new SEAG. Barbara, I think you're on mute.
I might. Had to happen at least once today. Thank you, John. I do want to acknowledge our observers who have joined us today. Jennifer Burns, Colleen Comrade, and Diana Stolfus. Sue Cosper, as I understand, will be joining us later. And unfortunately, Willie Botha is unable to attend today. So I don't see any hands raised. Maybe I'll just open it to see if anyone has any comments or questions before we move into the administrative section. Okay, great. So thank you, everyone. We're very lucky to have such a talented, diverse, and experienced group of members. I do want to just call out the 4 members that have agreed to serve on both this advisory group and on our investor advisory group. This was done to promote communication between the groups, and we're just very grateful for their dedication and commitment. So thank you, Lynn, Sandy, Jennifer, and Jeff. We'll now move to the administrative overview, and I would like to introduce my colleague, Ken Lynch, who leads our Office of General Counsel. As we mentioned, Ken will make a brief presentation focusing on the charter, and then we'll return at lunch in case anyone has questions. It's good that we're a little bit ahead of schedule. We would like to stick to around 20 minutes or so, since I want to make sure to allow adequate time for the division updates. Just noting that at last week's Investor Advisory Group meeting, we were a little short on time. Thank you. It's up to you, Ken.
Thanks, Barb, and welcome everyone, and congratulations on your appointment to the PCAOB's New Standards and Emerging Issues Advisory Group. And it was enjoyable for me to hear you all introduce yourselves, and I knew this was an impressive group, and it was great to hear all your short bios, and look forward to working with you all. I know a number of you sat through my presentation to the IAG last week, and you'll be hearing some of the same material, but there are some differences between the SEAG and the IAG charters. The topics I'm going to cover today include a discussion about the statutory authority for the PCAOB advisory groups, PCAOB Rule 3700, and I'll spend the bulk of my time on the SEAG charter. Could advance the slide to number 2. So under section 103 of Sarbanes-Oxley, the board shall convene advisory groups to make recommendations concerning auditing, quality control, ethics, independence, or other standards. And section 101 of Sarbanes-Oxley empowers the board generally to perform such duties or functions as it determines necessary or appropriate to carry out its mission under the Act. And finally, the DC Nonprofit Corporation Act, which is applicable to the board pursuant to Sarbanes-Oxley, specifies that a nonprofit corporation, quote, may create or authorize the creation of one or more advisory committees whose members need not be directors. And there are certain limitations on those. Slide 3. PCAOB Rule 3700 governs the formation, composition, and role of advisory groups to assist the board in formulating new auditing and related professional practice standards for registered public accounting firms. And Rule 3700 also calls for certain ethical duties that are applicable to advisory group members, which is all of you. Slide 4. The SEAG charter was adopted following consideration of public comments, along with the charter of the new IAG at a public meeting on March 29. It has 18 sections, and it addresses matters ranging from the SEAG's function to the selection, qualification in terms of service of members, and issues relating to particulars about meetings such as the one we're having today. The board has indicated a desire to enhance transparency, not only with respect to the development of the SEAG, but also with regard to how it will operate. Several key features of the SEAG charter, and that is the charter is posted on the PCAOB's website, merit special emphasis at this first meeting of the SEAG. I I will ask you all to be sure to read and refer to the charter itself. This briefing is not really intended to be a comprehensive overview, but just wanting to highlight several of the key provisions. Slide 5. Sections 1 and 3 of the SEAG Charter set forth the SEAG's purpose and duties, which are expressly tethered to the PCAOB's investor protection mission. The SEAG's authority extends not only to advising on standards, but also on matters other than standards, such as emerging issues that are of significance to the board in the pursuit of its mission. Determinations of any actions to be taken by the PCAOB and policy to be expressed within the board's authority on which the SEAG provides advice shall be made solely by the board. Should the SEAG not reach consensus, it may choose to provide the board with differing or a range of opinions. I will just point out that at public meetings, such as one today, differing opinions will no doubt be aired, and so the provision relating to providing the range of options really is more applicable to when we're talking about non-public meetings, because at public meetings, obviously everyone will be hearing what others have to say and the different viewpoints. Slide 6. Sections 5, 6, 8, and 9 of the SEAG Charter touch on certain ethics-related matters. Beth Horton, the PCAOB's ethics officer, will address those matters with you separately, but notably under Section 6 of the SEAG Charter, membership is personal to the individuals selected to serve, and members shall serve in their personal capacities and not as representatives of particular employers, and member duties and responsibilities, including attendance at meetings, may not be delegated to others. The board has taken great care in constituting the SEAG to adhere to the requirements of Section 6 of this charter, which establishes the number and qualifications of its members. Members are divided into 2 cohorts with staggered terms to facilitate continuity. The May 9, 2022 press release announcing your appointment specifies when your membership term will expire. Please note that the board retains authority in its sole and absolute discretion to remove any SEAG member at any time for any reason, with or without cause. Section 6 of the SEAG Charter expressly states that to enhance communications between the IAG and the SEAG, the board shall seek to have at least one IAG member also serve on the SEAG. We have 4, and I'll give them one more shout out in case you haven't memorized them yet. Jennifer Joe, Jeff Mahoney, Sandra Peters, and Lynn Turner have been appointed to both advisory groups. Slide 7, please. Sections 10 through 12 of the charter set forth certain parameters for leadership, setting of meeting agendas, and the meetings themselves. The PCAOB's chief auditor, acting chief auditor Barb Vanich, is designated as the SEAG's chair, and she is not a member of the SEAG. SEAG charter authorizes but does not require the board to appoint a co-chair from among SEAG members, and the SEAG chair or co-chairs are responsible for SEAG's carrying out of its meeting agendas. Those agendas shall be developed by the SEAG chair or co-chairs based on input from the board, PCAOB staff, and SEAG members, and shall be subject to board approval. Slide 8. Section 12 of the charter calls for activities and meetings of the SEAG, as I mentioned before, generally to be public, such that there should be no expectation of privacy in connection with your participation, which we anticipate will be recorded, made publicly available, and preserved for posterity. The SEAG shall hold at least 2 public meetings per calendar year, but may hold additional ad hoc public or non-public meetings. unless otherwise directed by the SEAG chair in consultation with the board, non-public meetings, including breakout and executive sessions, shall be closed to the public, but open to SEAG members, observers, invited experts, board members, and PCAOB staff. As far as quorum, a majority of SEAG members shall constitute a quorum. Slide 9. A PCAOB staff person designated by the SEAG chair shall serve as secretary of each meeting and shall prepare minutes thereof. Two attorneys in my office, Matt Golden and Damon Andrews, are serving in that purpose and will be preparing the minutes today. Non-public information as defined in Ethics Code Provision 9 of our code may not be discussed at any public meeting of the SEAG absent advanced board approval. SEAG charter contains provisions regarding the participation of experts and the attendance of observers at meetings. Section 15 of the charter calls for the provision of at least 2 weeks' notice for SEAG meetings. And Section 16 and 17 of the charter set forth particulars regarding voting and the procedural rules applicable during SEAG meetings. Slide 10. Talk about subcommittees and task forces. Subcommittees can be comprised of SEAG members only. They may be formed at the direction of the board when consideration of a particular matter would benefit from focused attention by a subset of the SEAG membership. The SEAG chair, in consultation with the board and SEAG members, shall specify the topics to be investigated. And unless otherwise specified, any subcommittee shall comprise those SEAG members selected by the SEAG. Task forces, which may include non-SEAG members, and that is the principal difference between the task forces and the subcommittees, may be formed at the direction of the board when consideration of a particular matter would benefit from the regular participation of individuals who are not SEAG members. SEAG chair, in consultation with the board and SEAG members, shall specify the topic to be investigated and the nature of any non-SEAG member perspectives that the SEAG desires to include in the task force. The SEAG may recommend to the board participants who are non-SEAG members. Appointments to a task force of non-SEAG member participants shall be subject to approval of the board in its sole and absolute discretion. Unless otherwise specified, any task force shall comprise all SEAG members who wish to be involved in carrying out a task. With that, I'll end as Barb mentioned at the lunch breakout. I and a colleague of mine, Matt Golden, will be there to address any questions you might have. I'll just say in general, really look forward to working with you all. If you have questions that you think are appropriate for me, or please feel free to reach out at any time. So thank you very much.
Thank you so much, Ken. Again, as I said, the session ran a little bit long at the IAG, so it's good we have some extra time. We're going to spend between now and lunch providing you with an overview of activities of the Division of Registration and Inspections, or as I'll refer to it as DRI, and the Division of Enforcement Investigations, which will be DEI, and the Office of the Chief Auditor, which at some point will get referred to as OCA. So we'll start with DRI and then DEI, followed by the Office of the Chief Auditor. George, would you please start us off?
Yes, be happy to, Barb. Thank you, and good morning, everyone. It's a pleasure to be here on the first meeting, and look forward to the discussion and look forward to your insights going forward. Having said that, what I'd like to do now, if it's okay, is provide I'll say a brief overview of DRI, the Division of Registration and Inspections, and some of our key activities that we've been performing for many years now and are performing currently. On the first slide, next slide, please. Thank you. On registration, so our first activity within DRI is registering firms, quite simply. Registration with the PCAOB is voluntary. However, any public accounting firm that prepares or issues an audit report on an issuer or a broker-dealer or plays a substantial role in the preparation of such report is required to be registered with the PCAOB. Currently, we have about 1,700 firms that are registered with the PCAOB. That number moves over time as firms withdraw for various reasons or there's mergers, and the firm number goes up or down, again, for various reasons. Of the 1,700, interestingly enough, about 50% are located in the U.S. and 50% are outside of the U.S. by happenstance. And in the firms that are outside the U.S., about 85 countries or jurisdictions are represented by those firms. From an inspection perspective, we've conducted inspections in around 50 jurisdictions cumulatively over the years, if you will. And of the total 1,700, about half have an inspection requirement. So not every firm that registers with the PCAOB has a specific inspection requirement. They register for maybe many reasons in anticipation of clients. So they're not being currently inspected as we sit here. But about 50% of those firms are being inspected or have a requirement on a current basis. Now, if we could shift to inspections, which is the bulk of our activities within the division, the Sarbanes-Oxley Act simply says that the PCAOB will conduct a continuing program of inspections to assess the degree of compliance of each registered firm and associated person of the firm. And it's assessing compliance with both SEC and PCAOB applicable laws, rules, professional standards, as well as the firm's own systems of quality control. So it's a very broad assessment that we go through on all of our inspections, both in terms of the firm's system of quality control, as well as over a selection of individual audit engagements or audit files and audit work papers. The purpose of an inspection is to accurately assess, drive improvement in, and communicate audit quality, both through our inspection reports and other publications that we might do periodically, such as spotlight documents. Now, the frequency of our inspections does vary. We have essentially two categories of firms. We have those firms that issue over 100 opinions in a given calendar year, and those firms are required to be inspected annually, or we would call annually inspected firms. Currently, there are 14 annually inspected firms. They're all located in the U.S. They're all domestic. That number has moved over time. It's actually been kind of ticking up a little bit because of merger activity by and large. But there's 14 firms that are inspected annually. Firms that issue 100 opinions or less are required to be inspected triannually or at least once in a 3-year period or 3-year cycle. And we would refer to these as triannually inspected firms. So we have annual firms and triennial firms, and all the non-U.S. firms currently are on a triennial cycle because they don't issue over or 100 or more opinions. In terms of the inspections and what we look at just at a broad level, we will interact extensively with firm personnel, both at an engagement level as well as at an overall firm level, whether it's national office or other personnel. We'll review firm audit work papers and other documentation that's necessary to support the inspection work. Each firm inspection, we do two parts. We have two parts. First is a review of the firm's system of quality control or the firm-wide procedures at the firm. And then second is a review of individual audit files or audit engagements, whether the firm is preparing them directly or potentially playing a substantial role or performing referred work in support of a group or a consolidated set of accounts or consolidated audit. Now, our procedures, I would say, are scalable. So our review of a firm's system of quality control at a large, say a Big Four accounting firm, is much more extensive than it might be for a two-partner firm with one or two issuer clients. The broader concept concepts of our QC procedures are consistent, but the level and depth of our work certainly does vary given the size, nature, complexity, sophistication, if you will, of an individual accounting firm. And it's also reflective of, given our history now, of items that we're aware of from prior inspections, whether it be inspection findings or other information that comes to our attention where we want to focus on at a given firm. In terms of the file selections, very quickly, that also will vary. For the major firms, historically, we've been inspecting a sample of files that range from typically from 50 to 55 files per year. And obviously at the smaller firms, that number would decline dramatically. But we are ensuring on each of our inspections, we are obtaining sufficient coverage to understand the overall quality of the firm's audit work across various audits, across various industries, and other characteristics that we might be focusing on in a given year. Our file selections historically have been both risk-based and random. We have a portion of each of our files, certainly at the major firms where there's multiple files to select from. The relative percentage of random versus risk has varied over the years. Sometimes random is a bit higher, sometimes it's a bit lower, but we do think conceptually having a random element is important to our overall file selections. Just to go back to the quality control for a second, areas that we focus on in the space of the firm's system of quality control cover things such as the firm's tone at the top. What are the messages coming from the senior leaders of the firm, the overall leader of the firm, as well as leaders of the audit practice in particular in the national office? Looking at the firm's policies and procedures around independence and ethics and how they're monitoring that activity and how they're communicating that. Training on audit methodology, technical accounting, other auditing matters. We want to understand how that's being done, how it's being assessed, how frequent it's occurring, what the updates are, the cadence of those updates. We'll look at the firm's client acceptance and continuance or retention policies and procedures, partner compensation, and the underlying drivers of the compensation framework. We will want to understand that. The firm's monitoring, what their internal inspection results are, is a big area of our focus across all firms. Again, it's scalable from the largest firms to the smaller firms, but conceptually, those are all key components and attributes and elements of our review of a firm's system of quality control. The inspection process, once we start with the firm, it's very interactive. We like to think we're engaging quite frequently with engagement teams, with firm leadership as we go through the process. If we do observe or identify what we believe is a deficiency or a finding, we will prepare a comment form, as we call them, which a comment form is just a vehicle, if you will, to formally communicate to the firm what our observation is. It'll have a facts section, and it'll have the underlying issue that we've identified, and then it would allow the firm, if it so chooses, to respond to the comment, whether they agree, they disagree. If they disagree, hopefully the firm will indicate the specific reasons and rationale why they think we're wrong or not, maybe understanding the issue as the case may be. We'll also ask the firm for what remedial actions they plan to take or are taking, as the case may be, again, if they so choose to respond. So the comment form is a key aspect in terms of our documentation of the output of our inspections. And ultimately, the comment forms will then feed into the inspection report, which is the next phase of the inspection process. Whether we have findings or don't have findings, every issuer, I'll say issuer inspection, will result in a firm-specific inspection report, which will include two parts. We'll touch on both of these here in the next few slides. There's a part one, which is public, that will ultimately go to our website for public viewing. Then there'll be a part two, which relates to the firm's system of quality control, which will not be made public, at least not right away, pending any remediation activities that the firm performs, and I'll review the remediation activities. Several years ago, as you may be aware, our inspection report format changed. We had a significant undertaking to revise and revamp our inspection format across all firms, whether it's annual or triannual. That resulted in 2018, if I recall correctly, the new report format coming out in inspection reports. As you can see on this slide, some of the key attributes of the new report format, though it's not so much new anymore, is an executive summary for annually inspected firms. The focus of our inspection report is certainly on the current year inspection. But with that, we do provide a number of data points, some historical information regarding the two most recent inspections, if that's applicable. We'll also provide other data points on the nature of our findings, the nature of the issues that we're looking at, the size based on revenues, et cetera. So we try to provide additional information and context for each of the reports, as well as some level of recent history, so there'll be a trend in the one report. In terms of the specific sections, Part 1 is the public section, as I mentioned. This includes observations that we've identified directly related to inspection observations of issuer work, of audit work. Part 1A, as it's now called, 1A, is audits with unsupported opinions, and these are audits where we believe the firm did not perform sufficient and appropriate work to support its opinion on the issuer's financial statements, including the report on internal control of financial reporting. We used to call that Part 1 historically. That's now Part 1A, and that threshold really hasn't changed over time. That's been a consistent threshold. However, we have created and established a Part 1B that was new with the new format several years ago. And Part 1B are items and observations that are not included in Part 1A, but they do relate to instances of non-compliance with PCAOB standards or rules. So some of the observations you might see in Part 1B would be CAMs, critical audit matter observations that we've identified. Audit committee communications is another area of frequent observation included in Part 1B. Part 2 of our inspection reports, as I mentioned a moment ago, relates to observations that we might have related to the firm's system of quality control. These are criticisms or potential defects in the firm's system of quality control. These will not be made public pending the firm's remediation period and the ability to address those to the board's satisfaction. Part 3 of the report relates to triannually firms only. This would include matters such as independence and things like that. And then Appendix A of the report is the firm's response to the draft inspection report. Again, if the firm so chooses to respond, the firm will have 30 days to respond to the staff to the report. Again, if they so choose to respond, and that would be made public with the report. The firm could have a public and a non-public portion of their response, so it would track with the report once it's finalized by the board. In terms of our overall process of inspection reports, the staff at a staff level and DRI level, more specifically, we will interact very closely with our colleagues in the chief auditor's office with Barb and her team. We will also interact very closely with our colleagues in the Office of General Counsel, Ken Lynch and his colleagues and his team as we go through the process. Whether we have specific questions about a firm's auditing procedures or interpretation of standards, we will interact very closely with various folks within the organization to make sure we're appreciating the application of standards, we're thinking about things correctly, we're applying the facts correctly. So we're very careful to ensure, to the best of our ability, we can reach the right conclusion, whether the firm agrees or disagrees, that we are on solid ground. Now, having said that, ultimately, the inspection report, after the firm responds or doesn't respond, the period expires, will be presented to our board for its consideration, review, questions, and ultimately support of our recommendation to move forward to a final report. There is a significant amount of interaction, not just with the staff, but also with the board as the board's reviewing many reports. We certainly do our best to address any questions or comments they may have to ensure they're comfortable with what we're including in our reports and a rationale and support for our findings. After the board's approval of the report, then the draft report becomes a final inspection report. The final report will be provided to others outside the PCAOB. For example, a copy could be provided and will be provided to certain non-U.S. regulators that have agreed to certain protocols. So those will be provided as part of the final inspection report process. In addition, a full report will be provided to the Securities and Exchange Commission, as well as various state regulatory authorities where the firm is licensed. So those organizations and entities will receive the report as well. The firm does have a right to appeal inspection reports through the SEC's process. There's a 30-day period after the approval of the report for the firm to decide whether it would like to appeal any of the findings. There's a protocol the firm will go through with the SEC, so reports will not be made public until after the expiration of that 30-day period, and we hear back from the SEC that the firm is not seeking approval. And then part one of the report will then be made available on our website. After the report has been approved, that will start the firm's 12-month remediation process. So we have a separate process after I'll call it our core inspection work. Then we'll move to the remediation phase where the firm has the ability to interact with staff and DRI extensively if the firm so chooses. And we encourage firms to interact with us as timely as possible, not wait to month 11, if you will, to provide the information. So we can provide real-time and ongoing feedback relative to their draft submissions that they're making. But during that 12-month period, the firm can take actions, make suggestions, and we will respond to their suggestions, provide feedback again during that 12-month period. The board has two documents on our website relative to remediation. There was a board statement in 2006 to provide perspective on the process around remediation. And then in 2013, there was staff guidance provided that provides more detailed information about how we think about remedial activities and actions the firms are undertaking. And it focuses around five broad criteria. The change, the specific change that's occurring based on the firm's actions they're planning to take, the relevancy of the change vis-a-vis the underlying quality control criticism, the design of the action that's planned, how it's going to be implemented or was implemented, and then ultimately the execution and effectiveness of the action that was planned, how the firm's monitoring the effectiveness of the actions. So we'll want to talk about and think about all those items as we work through the firm's remedial plan or remedial activities. Similarly to the report, the firm does have the ability to appeal a board determination or remediation to the SEC. So if our recommendation at staff level and if the board accepts that is negative or non-satisfactory, then the firm does have the ability to appeal that also to the SEC. And there's a process, again, like the reports with that. And before we would expose items on a website, we would wait to see that the firm has not actively appealing the remediation decision by the board. So that walks through at a very quick level and a high level our inspection process as well as the reporting remediation phases. On the next slide, just to give a quick overview of our common inspection observations. And these observations are generally speaking consistent whether it's a large firm, whether it's a smaller firm, whether it's U.S. or non-U.S. So areas such as business combinations, inventory, revenue recognition, internal control over financial reporting, ICFR, allowance for loan losses, and independence are our most frequently recurring findings, again, generally speaking, across all of our issuer inspections. And if I take a step back and think about the items, it probably is not all that surprising. These, generally speaking, involve complexities, judgmental areas for the auditor to work through, looking at, confirming, contradicting information from the company in terms of the overall audit assessment. So not probably all that surprising. These are the more common areas. Certainly, professional skepticism is a critical aspect as firms think about auditing, when a transaction occurs and goodwill impairment or intangible assets, etc. Independence is also an area that we always focus on to have from day one, and certainly are as we sit here today, thinking about the firm's procedures, policies around independence, and ensuring that they're complying with the applicable SEC PCAOB rules and requirements. And that's an area that we certainly do have concerns over, given the significant importance and foundational elements of independence to the auditor's role. And then the last slide before I pause, if I may, just a few words on our broker-dealer inspections. So we have our issuer inspections, whether it's a large firm or a small firm or smaller firm or regional firm, but then we also have our broker-dealer inspection program. Our broker-dealer inspection program was established with the Dodd-Frank Act in 2010, which gave the board specific authority over the registration, inspection, standard setting, and disciplinary authority over the auditors, of brokers and dealers that are registered with the PCAOB. We began 2011 with an interim inspection program. We are still currently in the interim inspection program for our BDs. Our BD inspections. We do not have individual inspection reports specific to the results of our inspections of firms doing the audits of brokers and dealers. We do, however, have an annual, I'll call it a overarching umbrella report that's issued every year in August. We're working very feverishly as we sit here today to have that report ready for the board review to be issued in August of this year. It's a very comprehensive report, has a lot of statistics, but it is not firm specific based, but does provide an overview of what we're seeing in our broker-dealer inspections. So with that, Barb, very brief and very quick overview. I'm happy to pause and take any questions or perspectives anyone may have. Thank you.
Yeah, again, please raise your hand if you have questions, and Jessica will call on you.
Christine Devine.
Thank you. First of all, George, that was a very informative overview. You spent some time talking about the two parts of the inspection, the system of quality control and the engagement team level. And with the implementation of the international standard at the end of this year on quality control and the impending PCAOB final standard, do you expect a shift more in the inspection process to the system of quality controls versus the engagement team level, or any other changes do you anticipate as a result of that?
Christine, thank you for the question. We've been, take a quick step back, we've been tracking, I'll call it, over the last few years with what the firms have been doing across all firms relative to the international standard ISQM1, because it's been such a large activity with the firms in terms of their QC focus. We have been, as many of you may be aware, starting a few years ago, increased our focus. We've always been focused on quality control, don't get me wrong, but we've increased our focus on the broader aspects of the firm's system of quality control to drive sustained and continuous improvement in audit quality. So it's been a focus for now several years. We are certainly discussing internally with Barb and her team, our QC standard, what that might mean relative to inspections. To answer your question specifically, to come back, sitting here today, would not anticipate major paradigm shifts of our inspection process based on the effective date of the international standard, but we will still want to understand what changes are occurring across the firm system, either because of that or because of other reasons, as we think about the impact on the quality of the issuer audits. So it will continue to be a major focus of us, but wouldn't anticipate a major change right now.
Thank you. Very helpful.
You're welcome. Thank you.
Brian Croto.
Yes, good morning, and thanks, George. I just had a couple observations, and I did also listen to the Investor Advisory Group meeting, and I know there was some feedback there too. But overarchingly, I guess I just wanted to comment that, and clearly, I think the inspection process over the last few years has been, nimble and thoughtful in light of everything going on from a COVID perspective, the macroeconomic environment, geopolitical, and the changes we're seeing from the use of data and technology. There's just a lot of change, and we do see that from an inspections perspective. A lot of change relative to the approach in response to that, even very quick pivoting from a COVID perspective relative to focusing on aspects of quality controls that might be implicated from that view, target teamwork across the firms and the like, and certainly I think that's all good relative to what the PCAOB is trying to accomplish and ultimately the objectives. I know that there's some dialogue around transformation of inspection reports, and I think there's a lot of positive feedback that we've heard and that we've had ourselves and the like, just relative to changes in the inspection reports that have been made over the years. And no doubt with a new board, there'll be continued look at that. And it sounded like you were commenting that may be the case, George, at the IAG meeting. And I know there's a variety of suggestions, including should issuers be named and the like. And I guess I would just suggest that there's probably a lot of benefit to reaching out and having some stakeholder outreach in that space, particularly for audit committees who, I think audit committee members are making a lot of use of inspection reports appropriately so and engaging with audit teams, and have found the recent changes over the last couple of years to be helpful. I think, having them as a sounding board as you continue to think about change would be good. With respect to issuers being named, and without getting into all the complexity around that, if you take like the National Transportation Safety Board, we all don't wait for annual reports from them before we step on airplanes. And I don't know that investors should have to look to inspection reports as the primary source of understanding whether they can rely on audit opinions, notwithstanding understanding there's desire for increased transparency. So I know the issue is complicated, but I just wanted to make sure I made the comment that, obviously firms have important responsibilities and obligations when there are inspection comments, and long before inspection reports are issued. If there's remediation that's necessary, those matters are addressed. So just given some of the IAG dialogue, I thought I'd add that to the mix and just give some overall perspectives on what we were seeing as an annually inspected firm.
Thank you, Brian, for that. The only comment I'll really make on that is maybe your first point. In terms of the nimbleness, we have tried over the years, almost since day one, to be adjusting to as we see new risks evolving well before anyone ever heard of COVID. What's happening in the macroeconomic space, what's happening in various industries, whether it be inflation, whether it be costs rising or decreasing, whether it be products coming in, mergers, acquisitions. So that's all continued kind of unabated, irrespective of COVID. But certainly with COVID, as I like to say, the unpredictable change continues as we think about what the coming months, looking into this upcoming year-end audit season will be, in the challenge there. I think we'll continue to, for the firms as well as for our inspectors.
Melanie Lubin.
Thank you. Really interesting presentation. I was curious how often the firms decline to respond to a deficiency comment letter and not work with your office to get things resolved.
Yeah, that's a great question, Melanie. I don't have the exact statistics in front of me. Certainly there are firms that don't respond. Usually these are in some of the smaller firm space, typically. It's not a large number where firms don't respond at all, but there are situations, and you can even see from our website, not all firms respond to the draft inspection report. In addition to firms not responding, some firms will respond with maybe lack of substantive responses, if you will. They'll say we disagree, but not really provide context or comment. That's probably something similar bucket, if you will. But that is something that we think about relative to a firm's system of quality control. If they're not responding or not, I don't want to say that they're not taking it seriously, but if they're not responding or reacting, that's kind of an indicator maybe how the firm approaches, how it views its role and its focus on audit quality.
And is there authority if they choose not to respond? What happens? Are they just re-inspected the next time and they'll get similar deficiencies, or is there any kind of regulatory follow-up to force them to be able to get into compliance?
Well, I would say to your last part, certainly, we can and we do accelerate firms from time to time if it's trying to triennial space based on prior inspection results or other maybe changes. So that's something we think about. We certainly are aware in the subsequent inspection the firm has not responded. Our antennas go up, if you will, as they say. But the other aspect is remediation. If a firm doesn't respond to remediation, the QC criticisms would become public automatically if there's no response, or if it's not a substantive response, we go through the board review process. And then ultimately, and I don't want to jump ahead to Patrick, but there's also an enforcement angle that, depending on the firm's results, that we do interact. We don't do enforcement. Don't get me wrong, but we do interact with Patrick and his colleagues, what we're seeing from an inspection perspective. I mean, as we do with Barb and her team about standards, and are the standards clear? So we're interacting kind of across the PCAOB to share information, but certainly enforcement's a key part of our discussions of what we're seeing at various firms.
Thank you.
You're welcome.
Keisha Williams-Smith.
Well, George, thank you so much for your discussion. Just wanted to get your thoughts on analytics and technology from the classroom to every space. I think in the profession, we're talking about that area. And I just want to get your thoughts on, from an inspection perspective, how are you all incorporating analytics and technology? Is that providing some efficiencies, and kind of what are you all thinking about as you look forward to enhancing the inspection process? So just kind of give us a flavor of what you all are doing internally, as much as you can, around the use of analytics and technology.
I would say we're on a journey with this, if you will, as we think about how we can better use technology and leverage technology. And I would even go so far, Keisha, say, is our data. So we pull in a lot of data from the firms, if you will, as part of our process, either through data request or just the ebb and flow of the inspection, how we assimilate that data, how we compare, contrast that data, if you will, as we think about risks and approach. I think there's a lot of aspects to it as opposed to just technology as we think about this. I think suffice it to say, we are very focused on it. We're working very closely with our Office of Technology. ODST is they're called, Office of Data and Technology, and thinking about our platforms for inspections. We have a new platform that we rolled out a few years ago relative to documenting our work and supporting our work that we think it has the capability as we continue to evolve with it to enhance not just our efficiencies, which is key, but also maybe more importantly, the effectiveness of how we can pull data points together and look long term. But I would say, and I'll pause after this, Keith, just because it's a great question. It's something that we think about. We think about the board a lot, and it's a journey right now. But we are very focused on, and I hope as we think, on a 2 or 3 or 4 year cycle, look forward, we'll be approaching ways to enhance the effectiveness and the efficiency of our inspection work.
John McComnick.
I also want to thank you for the presentation and also for all the work over the years. I'm not looking to jump ahead to potential standards or potential SEC disclosure standards, but under the current requirement for auditors to read and consider other information, does that factor into your inspectors? Do you ever ask how they've documented that they've read and considered other information?
John, thanks for the question. That's a very good question. As part of our inspection work, let me start here. Our inspection, we review the whole 10K filing. So we're reviewing, before we show up at the firm's offices and interact with them, we've reviewed the cover to cover, if you will, of the Form 10K filing. We've also typically reviewed any recent press releases or other information that the company's putting out, just to give us a broader sense in our own mind of the risks, of the areas of focus, and the challenges of the audit, and the areas of of greater subjectivity. Having said that, we are interested, broadly stated, as part of the firm's, I'll call it more the QC system, how they approach other information, what their policies are around that, more broad-based, to ensure that there isn't contradictory or conflicting information in other parts of the 10K. So that's probably the best way how we address it. And certainly, as we're thinking about information in 10K, if we're seeing things that we believe is not consistent or is contradictory, we'll have those follow-up questions with the engagement team.
Okay, but there's no formal requirement of documentation of read and consider the way there is of audit findings, for instance.
Well, from with an audit, if we observe, I mean, if I'm answering a question, stop me if I'm not, but if we observe an instance, I'll say conceptually, where we think there's conflicting or contradictory information in the 4-part of 10K compared to the financial statements, we'll want to understand what the firm did around that, and that potentially could lead to a comment form or an inspection finding.
Okay, thank you.
You're welcome.
John Bendel.
Yeah, thanks, George. Helpful context and presentation. I think you pointed out, and it's been really helpful, the evolution of the report on the audit firm and the issuers that are inspected. I would be just a little bit interested in going maybe a little bit deeper on what you're thinking on maybe evolution of that reporting. You mentioned, it might have been, or Brian might have mentioned, the dialogue at the investor advisory group, but I'd be kind of curious what you're thinking, the range of options you're considering, and the outcomes you're trying to drive with that. Thank you.
Yeah, John, happy to. I wasn't here for disclaimer, but I'll about to say that these views are my own, just to be clear, as I make a few comments. I think, first of all, at a broad basis, we've always thought over the years about what's in the inspection report, how do we make it more useful, how do we make it more meaningful, even more accessible to various stakeholders, whether it's investors, audit committee members, the firms, other users of our reports, because these can get very technical very quick, and if one's not understanding the technical literature, it may be hard to kind of unpackage some of it. So we've tried to write them in ways that is broad based. Now, having said that, to your question, again, we've been continuously thinking about our reports, as I mentioned, what will be useful. We've expanded to include prior year information. We've added more data points and factors around the issues that we're selecting, the size of the issues. Obviously, we have certain guardrails within Sarbanes-Oxley, at least right now, what we can disclose and we cannot disclose in our part one, part two. But things that I think broadly stated, what other information would be useful that we are gathering as part of our process to include in the reports? More information possibly, things broadly stated on the files we're looking at. Are there other data points that we could include around, is it a first-time audit? Is it a first-time inspection? Kind of things like that might be useful. I'm just now, again, this is my views only. Other areas that we might be able to expand Part 1B for that we've been thinking about, again, not there yet. So number of things. I don't think we're thinking about a revolutionary change of the report right now. But we always continue to think of ways to make our reports more useful. And I'll just say very quickly with that, there's the other piece, spotlight documents. So we've issued over the years, throughout the 12-month period, spotlights on various topics. And Barb and her team does something similar, whether it's Russia, Ukraine, whether it's looking at technology, whether it's focused on just the broader results of our inspections. So we think about those maybe together, if you will, how better to get information out to the public that's useful, meaningful, that will allow the various participants in the ecosystem of financial reporting to benefit from our work to help drive not just better auditing, but maybe also better financial reporting as a byproduct. Hope that's helpful.
Preeti Chowdhury.
Good morning, George. Nice to see you again. We have, 20 years of data now that the PCAOB has been doing inspections. And I'm wondering if, as a follow-up to the PCAOB's 2015 audit quality indicators, I don't know, white paper, I don't know what you would call it, has DRI considered doing some data and analysis on some of those audit quality indicators and publishing anything for audit committees to see to learn from in terms of drivers that would make sort of broad conclusions about the inspection process?
Yeah, thank you, Preeti. Good to see you as well. I'll focus my kind of response on DRI specific because it's a broader question. But from a DRI perspective, we've been thinking, even before the concept release you referenced in 2015, are there drivers, are there key drivers or key indicators, whatever you may want to call them, of audit quality, or things that if one sees tends to maybe lead to a good outcome or maybe not a good outcome. So we've been thinking about those over the years, interacting with firms and getting their perspective on that. Now, in terms of publishing something or relative to the concept release or others, I might defer to others on the call to weigh in on that. But it is from an inspection perspective, it is certainly something we think about, whether it be the relative number of hours on a given engagement, whether it be the project management around when work occurs throughout the year, or other factors, use of specialists and things like that. And a number of those data points, broadly stated, would show up in firms' quality reports that they're publishing, fairly frequently now. But it is something that we certainly are focused on. What other drivers of audit quality?
Jennifer Joe.
Hi, Brian. Thank you for taking the time to give us some background. Wanted to know your thoughts on one concern that's been raised in academic research is that auditors are concentrating considerable effort towards preparation for their inspection, as opposed to taking sort of a risk-based approach. And some of the evidence that has come forth through academic research is that the audit teams will focus on documenting the issues highlighted prior to inspections or on the inspections agenda, also concentrating a lot of their time and effort on documentation in order to avoid an issue being raised in inspections. So can you comment on how your team is sort of working to make sure that the inspections are meaningful in determining auditors' efforts in terms of assurance over management's reporting, rather than being led down the garden path by auditor documentation?
I'm sure that's a great question. And we probably could spend all afternoon on that question, truth be told, because there's a lot of pieces to it in all seriousness. I think that the first part of how we think about it, going back to how we pick our files, So our file selections, it's probably fair to say are primarily risk-based, but by the same token, we do have a random aspect to it. And in addition to a random aspect on which files we select, we also have a notion, which I didn't mention, but we have a notion of non-traditional areas. So, certainly revenue is an area we look at significantly. So, can firms, engagement teams think, well, gosh, if this file's selected, well, we know they're going to pick revenue, so let's focus a lot of attention there, maybe to the exclusion of other areas that may need equal or more attention. So that over time led us to the view, well, maybe we should be periodically looking at other areas that may be somewhat unexpected, whether it be cash or debt or things like that that are material, don't get me wrong, but maybe not always have the highest risk characteristics as revenue or allowance for loan loss. So we do layer in, if you will, in our selections other areas. And I say to come back to your question, so if a firm or an engagement team is trying to second guess or focus specifically on where we're going to inspect, the random aspect in the non-traditional area we think helps to level the playing field, so to speak, that the firms need to focus on audit quality holistically as opposed to trying to second guess what might happen if there's an inspection to drive that process. Certainly, I think to the first part of your question about the time and effort goes into an inspection, we recognize that there's significant amounts of time that go into the inspection to prep for it, to go through the actual interaction with our inspectors. And I'm not sure how to avoid that, but that's probably part of the process. So I pause. Hopefully that's responsive to your question.
Yes, it is. Thank you very much.
You're welcome.
Jeff Mahoney.
Hi, George. Great presentation last week and even better this week. So thank you for that.
Just come back next week, it'll be even better, Jeff.
I'm sure it would. Follow up on the IHE meeting. So there's a lot of talk about audit quality indicators. So following on to the professor's inquiry, could audit quality indicators potentially be integrated into the inspection report? And is there any process or vehicle where that idea could be evaluated?
Yeah, Jeff, great question. I think our inspection reports, again, I'll say again, this is myself speaking. Our inspection reports provide a great platform for us to communicate, us being the PCAOB, a lot of information through that process. Again, keeping in mind the public, non-public aspects of it. So certainly, as we think about ways, not saying we're there right now, but ways to enhance the inspection reports, I think things like that are things that could easily be considered. I think the one challenge will be potentially is there a consensus around which ones are the most meaningful and the most useful? And then I think the other aspect, and this is not a reason not to do it, but just something I think we would want to think about is the context of them. So it's one thing to have a table or chart of a list of data points and say, well, here they are, and then move on to our inspection findings. But what's the context around those? And does that provide enough information, that chart, so to speak, as I'm speaking out loud here, does that chart provide enough information, or does it just raise more questions about, well, what does it mean in context? So I think those are things, to your question, that we'd want to think through, if we do go down that path, again, a big if, what it would look like and how to provide that context. But certainly conceptually, what's driving audit quality, go back to the prior question, what's driving audit quality is something that we do think about quite a bit in our discussions with the firms. It's not lost on us that there are key performance indicators or AQIs, whatever one wants to call it, or drivers of audit quality that seem to have greater impact than others as we think about across all firms. So something we'll continue to think about, Jeff.
Thank you, George.
You're welcome.
I think we've gotten everyone that had questions for George. So let's go ahead and move to Patrick Bryan. Again, Patrick's our Director of the Division of Enforcement Investigations. Patrick, over to you.
Great. Thanks, Barb, and good morning, everybody. It's a pleasure to be here. Happy to give you an overview of the Division of Enforcement Investigations, or DEI. And so the division is composed of approximately 60 professionals and staff. On the professional side, we have both attorneys and accounting professionals, and we have folks with a very deep bench of experience on both sides of the profession, and including an amazing support staff, primarily based here in DC, but we also have folks in New York and Chicago. So today I was intending to give you a broad overview of DEI and what we do, and at the end I'm happy to address any questions. So the board exercises its investigative and enforcement authority through DEI. And what I mean by that is DEI doesn't have any independent enforcement authority. We make recommendations to the board, and the board determines whether to bless a settled order, initiate litigation. All of those matters, the board retains broad discretion in determining the appropriate outcome, the appropriate sanctions for a particular case. And DEI staff, of course, plays an integral role, but ultimately the board retains authority in terms of what enforcement actions to take. The board also has very broad investigative authority. The board can pursue enforcement or disciplinary action against any public accounting firm or associated persons thereof for any provision of the Sarbanes-Oxley Act. For example, Section 105C6, failure to supervise provision of the Act, is a provision that we've recently applied in some enforcement actions this year. Of course, the rules of the board, the provisions of the security laws that relate to the preparation or issuance of audit reports, and PCAOB standards. The board can impose a variety of sanctions if violations are found, and I'll talk about what those sanctions are in a moment. But first, I did want to take a step back and provide you with an overview of what we in DEI view as our mission, our vision statement, if you will. And so our primary mission is to protect investors, and we advance accountability and deter improper conduct. And we do so through maintaining a leading enforcement program, a global leading enforcement program, and one that promptly investigates and prosecutes serious violations of PCAOB standards or rules. This vision or this mission statement governs how we allocate our internal resources and what we do. And for example, we undertook an internal analysis to look at our process and look at ways that we can more quickly or more efficiently advance investigations, because we do thoroughly believe that a key aspect of being a global leading enforcement program is to move quickly. And these are very complex investigations. Very often they do take an extended period of time, but we're always looking internally to see ways we can improve our own processes. And in choosing our priorities consistent with the board's strategic plan, of course, protection of investors and deterring improper conduct are front and foremost on our minds at all times. So next, I want to switch to just the sources of our investigations. And first and foremost are the inspection reports of registered firms. And Georgia had mentioned that we work closely and collaborate on enforcement referrals to DEI, and our teams are in constant contact. We have regular touch points on both the global network firms, the largest firms, as well as the non-affiliated firms, the 2,000 or so non-Big Six firms. So we're constantly discussing what inspection findings are coming up, issues that are coming more broadly in inspection findings. And just to put a little context on this, in terms of the number of settled orders that we issued last year was 21. 12 of those were based on DRI inspection-related referrals. More than half of our existing investigations and inquiries are based on inspection referrals. So our collaboration with George and his team is vital to our success in the enforcement program, and has historically and continues to be the largest source of our investigation leads. The second largest source of investigation leads is what we call our public source analysis group. This is a team located in Chicago and DC. That team reviews not just news reports, but a variety of other sources, short seller reports, public filings, 8Ks. We look for dismissal or withdrawal of auditors. We look at our own disclosure filings, Forms AP, Form 3, and others, looking for data. For example, in Form 3, contested proceedings against a particular firm, if they implicate any audit issues, that public source analysis group makes a recommendation to an associate director within our department, and we open a variety of investigations based on that public source analysis. Thirdly, we do have a tip line. We are increasing the prominence of the tip line on our website and looking for ways to continue to promote the tip aspect of our investigations. We do not have, like the SEC, a bounty or reward program for folks who give us tips that lead to actionable enforcement action. But nonetheless, we do get a strong number of tips every month. They are assigned to a duty officer, typically one of our accounting professionals, who will examine the content of the tip, follow up with the tipster to the extent they're willing to engage with us and not remain anonymous, gather additional information, and that duty officer will make a recommendation indirectly to me. It goes through an associate director, and ultimately it's the director's responsibility to approve any investigations or inquiries. And so the tips remains a large part of our investigations as well. And then finally, as you can imagine, we do cooperate regularly with other regulators. First and foremost, the SEC. We have regular touch points with SEC enforcement staff. We coordinate on investigations very often. There will be tips from other regulators. FINRA, we also get broker-dealer referrals from FINRA. So the other regulators are often a source of investigations, and we continue to collaborate with them in parallel and concurrent actions from time to time, in particular the SEC. Our priorities have been fairly consistent for the last few years. We are focused on those violations that will have the greatest risk to investors. So first and foremost, significant audit violations that pose a risk to investors. We are also laser focused on independence-related issues, as is the SEC, and that continues to remain a #1 priority for us. And then finally, a priority area is what we call non-cooperation matters, threatening the board's oversight integrity. So that would be either the inspection process. Folks continue to engage in conduct which misleads inspectors, or they could not cooperate in our ongoing investigation. And so we continue to see unfortunately, a number of cases that fall under this category. Now, I will say, although these are our top priorities, we have been thinking more expansively about our approach to enforcement and thinking about alternative theories that we can bring additional enforcement actions. These will remain our priorities, but we're also looking at enforcement sweeps in a variety of different contexts. We are considering alternative charging theories. I mentioned the failure to supervise theory that we brought recently this year. But we're continuing to press the envelope and think critically about ways that we can be more expansive in our approach. Next, I want to just clarify, we have two types of investigations. We have what we call an informal inquiry and a formal investigation. Most matters will start out as informal inquiries. So as I mentioned, when a tip comes in and a recommendation is made to the director, we will open an informal inquiry, and that allows us to commence an investigation of a registered firm or associated person. The requests are voluntary. We typically get a high degree of responsiveness in these voluntary requests at the informal inquiry stage. We cannot compel the production of testimonies or documents absent a formal investigation. So next, the formal investigations, as I mentioned, these are matters that the board has approved, a formal order of investigation. So we make a recommendation based on our findings in the informal inquiry, where we believe that there is likely a violation of our rules or standards or other rules within our jurisdiction. And the board will issue a formal order which would permit us compel the production of documents, compel the testimony of associated persons, and we do so through what we call accounting board demands, akin to a subpoena, but the folks who are registered with the PCAOB are required by rule to comply. If they do not comply with an accounting board demand, then we can bring a non-cooperation action against either the firm or an individual under Rule 5101. Next, I want to talk about the range of sanctions. As I mentioned earlier, there are a broad range of sanctions available to the board, from a suspension of an individual or an outright bar from the industry, which is a very severe sanction, particularly associated persons of the larger firms, the big four, for example. That is a very significant sanction. We can revoke the registration of a registered firm, limit the activities or functions or operations of a firm. For example, the board can order that no additional issuer audits be undertaken for a period of years, or place supervisory restrictions on individuals. And we can also appoint an independent monitor. And when I say we, again, of course, the board ultimately can appoint independent monitor. We have done so from time to time. I will say on the range of sanctions, thank you. In a disciplinary proceeding, the sanctions differ depending on the level of what we call scienter, which is the mental state of the perpetrator. So in order to bar an individual, to suspend or revoke a license, we would have to show that they engaged in intentional, knowing, or reckless conduct, or they engaged in repeated acts of negligence. And so there's a body of case law giving more context and meaning to those terms. But a single act of negligence, the statutory maximum penalties for single act non-heightened sanctions, what we call them, are still somewhat substantial. For an individual, for a single act of negligence, the penalty is approximately $153,000. For a firm, it's $1.14 million. And those sanctions go up dramatically if we can show intentional, knowing, or reckless conduct or repeated acts of negligence. Next slide. The majority of our disciplinary actions are settled. They are resolved by consent, with the board issuing a settled disciplinary order. If the respondent chooses not to settle, we have a litigation process, a contested litigation proceeding, in which the board issues what we call an order initiating proceedings, OIP, and that's akin to a complaint in a federal district court, except the OIP is presented to the hearing officer, a board hearing officer, who will conduct an on-the-record hearing, hear the witness statements, admit evidence, and make an initial decision. Any sanctions imposed by the hearing officer at the conclusion of a hearing can be appealed to the board, which reviews the initial decision de novo, starting from scratch, reviewing all the decisions of the hearing officer and the evidence on its own accord. And then ultimately, any board decision can be appealed to the SEC, and from there to a federal appellate court. Contested proceedings, as you may know, they are non-public. So a lot of what we do is not seen by the public. We have filed 3 contested actions this year already. We expect a 4th in the coming weeks. And so we do expect an increase in litigation in the upcoming months and years. And so the hearing officer process, although historically 95% or so of our enforcement actions were settled, we think the numbers are going to shift to more disciplinary proceedings before a hearing officer. I mentioned our coordination with the SEC and FINRA. We do have a practice of coordinating with them at the inception of any investigation, we do our best not to duplicate efforts. However, I think we're likely to see more concurrent actions in the future. We can coordinate with FINRA on matters related to broker-dealers. And our coordination with the SEC, I think, has been very strong and continues to be a strong relationship that we value very highly. And we also have, through our Office of International Affairs, we work with our foreign counterparts where appropriate. I think about a third of our investigations are cross-border. And so we have a considerable number of statements of protocol with foreign jurisdictions and foreign agencies that can assist and participate in any investigation, PCAOB investigation that involves a foreign jurisdiction. So there, I thought I'd end on enforcement highlights. I think our current profile, pipeline is very strong. We're poised to exceed the orders we issued in 2021. I think we got off to a little bit of a slow start. We've issued 8 settled disciplinary orders to date. I mentioned we also had initiated at least 3 litigations already, but we do expect increased activity in the 3rd and 4th quarter. And we're certainly focused, and the board is focused on increasing the deterrent effect of our sanctions, particularly the penalties. I mentioned one of the reasons that we expect increased litigation in the future. I think as we up the expectations for penalties, that there may be a disincentive to settle. And so as we ramp up the sanctions, certainly we expect more litigation, but as the message gets out to the industry and the defense bar that sanctions are going higher, maybe we'll see some leveling off in the future. But we're very excited about the upcoming year, or this year, and very excited about the things that we're doing in terms of expanding our enforcement approach. So let me pause there. I'm happy to take any questions.
Jessica, we saw a question in the chat for George. Let's take that one in case George needs to drop off, and then we'll turn to any questions for Patrick.
So, George, I'm not sure if you saw the question in the chat, but it's from Lynn Turner. How many inspectors does your division have now, and how does that number compare to 4 years ago?
Great question, and I appreciate that, Lynn. Thank you. Well, let me start by saying we've been hit by the Great Resignation, like the rest of the world. So we're down compared to 4 years ago. In 2000, I think it was 17, we had a voluntary exit program. So we dropped in 2017, early 2000, I guess 2017, and we were fairly constant. Our budget number was 480. For a period of years. We're beneath that now. It's a very challenging environment. We've been having a number of conversations internally across the organization about, not just for DRI, about headcount, and we're certainly looking to increase our numbers as we go throughout this year and into next year. It is something that I think it's fair to say, many of us are staying awake at night thinking about resources and how we maintain our effectiveness and our capacity to maintain what we've done in the past, if not expand it in certain areas, and be responsive to ongoing risks. So it is an area of focus. But overall, directionally, we're down compared to 4 years ago.
George, this is Dwayne. For clarity, I think the budget is up. Is that a fair statement? I mean, you're down in actual space, but is the budget, to be
correct?
Helpful to understand the budget.
Yeah, the budget for 2022, the budget was increased, which I'm very thankful for this current calendar year, to around 500, but we're beneath that as well. So head count, people in chairs, so to speak, for that time period you referenced, we're down, even though the budget is increased.
Thank you.
So thank you, Dwayne.
Lynn Turner. You're on mute.
So how many inspectors do you have now?
Right now, our head count for DRI which is mostly inspectors, Lynn, is about, we're around about a little bit above 450.
Okay, thanks. Good luck on hiring.
Thank you.
Lynn, you also had a question for Patrick. Do you want to go ahead and ask that question?
Sure. Thank you. Patrick, there's been the recent opinion in the Fifth Circuit down in Louisiana with respect to the SEC's ALJ program. What impact, if any, do you anticipate that may have on your ALJ program?
Lynn, I think that clearly the opinion was a surprise. I think we have good arguments to distinguish us from that opinion. I think I'd defer to Ken and OGC. We've looked at it. We're coordinating our thinking on that, but clearly that's as I said, it was a surprising opinion, but we're pretty confident we have good arguments that would distinguish us.
Thank you.
Yep. Clearly, it's something we have looked at very closely, and preliminarily, we don't think it's going to have the kind of negative impact that it could potentially have on governmental organizations and agencies.
Thanks, Ken. Jeff Mahoney.
Patrick, thanks for the presentation. I appreciate it. I promise I'm not going to rehash everything that was discussed at last week's IAG meeting, but there's one point that I think is important. So I wonder if you can just briefly touch on it again, and that's the issue of non-public proceedings and what impact it may have on the timeliness and the quality of PCAOB enforcement. And then second, given that, would you recommend to the current board, as some prior boards have done, that they publicly request that Congress pursue legislation to fix this issue so that your enforcement actions are consistent with the SEC as far as being public?
Well, Jeff, I'll give the same disclosure that George made, that these are my own views. I don't want to get ahead of our other stakeholders or board. In terms of the timeliness, I think clearly the non-public nature of contested disciplinary proceedings extends the time to a public order and can extend the time to a number of years. If you include the appeal to the board and to the SEC until the SEC renders a final decision, the matter remains non-public. The timeframes have varied, but we've seen some very long timeframes in outlier cases. So my view is that the non-public nature does have a deleterious effect on enforcement. Whether the board should publicly advocate, I'll defer to our board members. In terms of the quality, I think we have great litigation resources in our people, and they put together strong records for consideration by the hearing officer and ultimately by the board and even the SEC. So I don't think the non-public nature impacts the quality, but certainly the timeliness.
Thank you.
Preeti Chowdhury.
Officially, good afternoon, I think. Nice to meet you. I had two questions. My first question, you gave us a nice overview of the various sources that could generate, some sort of enforcement action and then what would happen and the various outcomes. But my question was more about what if there isn't an enforcement action? Is there a process to consider whether guidance may still need to be revised or clarified? Because perhaps the behavior you're seeing is not really what the regulator would like to encourage, and but it's not sufficiently clear that they've violated a standard, but perhaps there needs to be more clarification in the standard. That's my first question.
Sure, and I think historically enforcement has done spotlights in the past, and certainly we considered doing so in appropriate circumstances going forward. I think we do work closely with DRI and our colleagues in OCA, Barb and her team, on issues of note. So there's risks associated with Ukraine. We recently did a spotlight there that touch on enforcement inspections and areas where there is some ambiguity about what firms should be thinking about and areas that we want to highlight. I am cautious about enforcing through regulation where there is not a clear path forward, but I think some staff guidance, it can be used in appropriate cases. It's just not something that we've relied on in the recent past, but certainly I think we're open to considering it.
I guess I would just encourage this as perhaps a different avenue, given the, the overall board's goal to kind of really ramp up on standard setting, that this might be a good place to look for opportunities to improve some guidance. My second question was, has your group considered any sort of voluntary coming forward program where you would not give as, very harsh penalties, I guess I would say, but perhaps encourage people to come forward? Some different regulators, in different places have done that in the US and found some success with those programs. And I don't believe the PCAOB has such a program.
Well, we actually do have a policy on substantial cooperation credit that is available on our website, and many firms have availed themselves of that. That policy requires that firms or individuals go above and beyond what is legally required or required of a registered firm. So we've had examples where, particularly with foreign affiliates, where we may have difficulty conducting a very prompt investigation on our own, where foreign affiliate will conduct an internal investigation, share the results of that, provide witnesses available for testimony, and take a number of steps that really underscore that they're substantially cooperating and making our investigation, assisting our investigation in an active way. So in those circumstances, we have offered the firms reductions in their overall penalty. And so there have been a couple orders, I think, in the last 12 months in which firms have availed themselves of that. We're encouraged by what we've seen thus far. We certainly want to promote that policy because it does have a positive impact, prompt reporting, taking disciplinary action against wrongdoers, those kind of steps. We are encouraged to see and hope that through continued promotion of that policy, we'll see more firms take advantage of that.
And is that public? Do you note in the outcome that somebody had substantial cooperation and therefore received a concession?
Yes, the board's orders in those circumstances will highlight that the firm did substantially cooperate, and as a result, the ultimate sanctions imposed were reduced.
Thank you. And our last hand, Dane Mott.
Thank you. In your comments, you mentioned how the SEC has its whistleblower program with the reward system, and the PCAOB does not. Are there any interests or efforts where perhaps the PCAOB would try to pursue those types of initiatives? Because I think the SEC's had great success with that program.
Sure, the SEC certainly has had great success, and there have been proposals on the Hill that I'm aware of that have suggested a similar approach. I think it would require a legislative change. Speaking again on my personal behalf, I think that would be a great outcome, but I defer to members of Congress on whether they wish to go down that road. But certainly, it's been a very effective tool for the SEC. And speaking personally, I think I'd love to have the same or similar tool at the PCAOB.
Thank you so much, Patrick. We'll move ahead. We have about 11 minutes before our planned break for lunch. Since you'll have plenty of time to spend with me in our last session, just going to talk very briefly and keep it high level and share a little bit of information about our process. Um, Again, encourage questions to the extent we have time. If you have questions you think of later, we can always pick them back up in the discussion of the agenda. So I'll just give it a second to get the slides up. Thank you, Danny. Whoops, losing my place. So I'll talk a little bit, focusing mostly on our process. But in general, we seek to establish and maintain high quality auditing and related professional practice standards for audits in support of the mission to protect investors and further the public interest in the preparation of informative, accurate, and independent audit reports. Now, our standards include auditing and attestation standards, quality control standards, and the ethics and independence standards. In audits of issuers and broker-dealers, registered public accounting firms must follow the PCAOB standards. Those auditors must comply with both the SEC's independence requirements and our independence requirements. Many of the independence requirements are the SEC's. Our independence rules focus primarily on prohibiting contingent fees, certain tax transactions, and tax services for persons in financial reporting oversight roles. We also have several rules related to the audit committee's pre-approval of certain tax services and non-audit services, and also a communication requirement with the audit committees concerning independence. What makes our process a little different than other standard setters is once our board adopts a standard, the SEC has to approve it. The Office of the Chief Auditor advises the board on the establishment and application of auditing and professional standards. In addition to standard setting, we develop staff guidance and other staff publications. In developing standards and guidance, we work, as you've heard from my colleagues, very collaboratively with the Division of Inspections Enforcement. And I don't want to forget the Office of Economic Research and Analysis and the Office of General Counsel. We primarily think about our activities in three phases. And so on an ongoing basis, we devote time to understanding current and emerging audit issues. This can include, for example, monitoring the activities of other audit standard setters and regulators, or monitoring specific topics, including, for example, crypto assets, developments in ESG reporting, or other non-GAAP measures. We seek input on a consistent basis from our colleagues in DRI and DEI and ERA, and also through the Office of External Affairs Outreach, and now once again through our advisory groups. As a result of our efforts, we may issue staff guidance or a staff publication to highlight relevant audit considerations. It can also result in an issue being elevated to our research agenda. We also work on research projects. With respect to the projects on the research agenda, we're exploring whether standard setting is needed, or is the right answer staff guidance or some other action by inspections or enforcement. In the research phase, we obtain input and seek diverse perspectives throughout the process, which may include getting external input from our advisory groups or from the public more broadly by issuing a concept release or a staff consultation paper. We focus on identifying the problem and we brainstorm potential solutions and then work with our board to determine whether to advance the issue to the standard setting agenda. Now, our standard setting projects, which we'll be covering in detail this afternoon. In this phase, we're focused on developing a standard and a release with the ultimate goal of the board adopting a final standard. The standard setting phase generally includes issuing a proposal to elicit public comment, and then based on the comments received, we may issue a re-proposal, a supplemental request for comment, or move to recommending the board adopt a final standard. Again, when the board adopts a final standard, it's submitted to the SEC for approval. Prior to SEC approval, the standard is published in the Federal Register for public comment. And so we'll talk again more about the specific projects later today. A couple of other things just about our rulemaking process. So although federal law does not require us to use particular rulemaking procedures, for example, the Administrative Procedures Act, the PCAOB, like other standard setters and U.S. federal agencies, generally follows a notice and comment process to develop standards. The process typically involves issuing or proposing a release for comment. It can also involve additional steps, such as publishing a concept release to help determine whether a proposal is needed and what form it might take, or issuing supplemental requests for comments to refine a proposal. Sometimes we seek input in advance of proposed rulemaking through advisory groups or other public meetings. An important aspect of our process includes economic considerations, which include consideration of the need. So when publishing a proposal, we describe as clearly as possible the need for standard setting and explain how the standard would meet that need. The baseline to assess the potential economic effects of a new or revised standards, we first establish a baseline against which to measure the impacts of the new or revised standard. The baseline analysis would discuss the current standards, the new or revised standards, how it will affect practice, as well as how we understand the current range of audit performance and market behaviors found in practice. Alternatives considered, we generally describe why standard setting is preferable to other regulatory approaches such as guidance. And as far as economic impacts, we identify the likely benefits, costs, competitive effects, and potential or unintended consequences of a revised or new standard. Another matter you will see addressed in our releases are emerging growth companies. The Jumpstart Our Business Startups Act of 2012, or the Jobs Act, requires that in order for a standard to apply to the audits of emerging growth companies, the Commission must determine that the application of such additional requirements is necessary or appropriate in the public interest after considering the protection of investors and whether the action will promote efficiency, competition, and capital formation. So through our rulemaking process, we do provide information to aid the SEC in that determination, and we're aided in that by our OERA colleagues who consider the effects of the standard on emerging growth companies. For those of you who are interested in the topic, OERA periodically publishes a white paper that's available on our website. Subsequent to the issuance of a new standard, we assist our colleagues in OERA in post-implementation reviews on how the performance of a standard has gone. We also support the implementation of standards and rules through written guidance, webinars, or other channels. For example, we speak publicly and we participate in the board's small business forums. And we also, again, periodically prepare publications that we believe are important to audit quality, such as in the beginning of April, we published a spotlight on the recent invasion of the Ukraine and the potential audit impacts, and also assisted with several publications on COVID. I know that we're about time, so I'll pause there to see if we have any questions. And again, please don't feel rushed. I'm happy to take questions in the later session. Maybe that everyone is ready for a break.
I don't see any questions.
Okay, well, with that, we will get 2 additional minutes for lunch, and thanks for the great participation this morning. Again, the public meeting will resume at 1:30. Would like members to return around 12:50 for a briefing from our Chief Compliance and Ethics Officer, Beth Horton. And as mentioned, Ken Lynch and Matt Golden will be available to answer questions you might have on the charter. So thank you, and to the public, we'll see you again at 1:30.